Mr. Chairman, the Catholic Bishop of the Sunyani Diocese, the representative of the Lady Chief Justice, the Vice Chancellor of the Catholic University, the representative of the National House of Chiefs, the representative of the Regional Minister, our friends from the United States, members of the Pro Africa who are here, participants, ladies and gentlemen. It is my pleasure to be called upon this morning to give a brief background to ADR in Ghana. Before I begin, I would, I'm sure, find time to recommend to the chairperson of ADR in Ghana that we should give an honorary certificate to the regional minister for his wonderful exposition of ADR. And I'll be glad to carry the certificate to him at any time. Ladies and gentlemen, access to justice in one form or another is a need that has existed in human societies. And before Ghana was colonized, the people in what became known as the Gold Coast colony had evolved for themselves a well-organized system of government which provided an access to justice that particularly suited their society. At the family, clan, and even village-wide level, Ghanaians have developed dispute resolution processes that had at its core participatory, interest-based, consensual ways of resolving disputes. Interaction between our forebears and the harbingers of colonial rule, especially the British, led to the signing of the infamous Bond of 1844, which effectively made Ghana what had been christened the Gold Coast colony of the British Empire. But even under colonial rule, the people of the then Gold Coast continued to resort to their time-honored means of dispute resolution, which eventually became known as customary law arbitration and negotiations for settlement. Indeed, the chiefs, the family elders, the members, we wish to acknowledge the presence of Nana, who has been a wonderful person in the ADR program in the region. And as I was saying, even under British colonial rule, chiefs, the heads of families, continued to practice what we may call African dispute resolution practices. Indeed, the chiefs had state-recognized judicial powers and held courts in their palaces. In 1876, however, the Supreme Court ordinance established the Supreme Court of Lagos as the superior court of all nearby colonies, including the Gold Coast colony. Following this, legislation were introduced which progressively stripped chiefs of all state-recognized judicial powers and placed judicial powers in the hands of lay and professional magistrates. Thus began the emphasis on the judicial resolution of disputes, otherwise known as adjudication in what is known as present-day Ghana. The British system of judicial resolution adopted litigation as the primary method of dispute resolution. The main feature of litigation as a means of resolving disputes is that parties come to the court as adversaries, seeking to vindicate or defend a legal right. In adjudication, the contest of necessity had to be couched in distinctive justiciable issues in order to disclose a legal course of action that could be adjudicated upon. If no legal or equitable course of action could be disclosed, then the matter would not be subjected to adjudication. The main role of the judge was to supervise the parties or their lawyers as they battle to vindicate their legal rights. As more and more people left their villages to live in the emerging towns and cities that were developing, the more they lost touch with the traditional norms, including the African way of resolving disputes. In the course of time, therefore, adjudication replaced traditional dispute resolution practices as the main or primary means of dispute resolution. Now, the premise of litigation is that it is a contest in which one side must win and the other side lose. It therefore easily leads to a situation where parties concentrate on winning the dispute rather than focusing on resolving the same. There was also the assumption that there was only one way of resolving a dispute, the legal way. So every dispute had to be crafted as a legal course of action. But the sad reality was that as lawyers concentrated more and more on crafting people's problems into recognizable legal courses of action, the less attention they paid to the real needs of the parties, a simple desire to have their problems resolved. The very nature of the court system and the way the court comes to its decisions also became problematic for the people. A court's decision necessarily involves proof of facts and the application of the law to these facts. A decision on the facts depends on the judge's evaluation of the evidence. This is not an exact science. Honest evidence may be incomplete because the parties and their witnesses may not be able to recall the matter which had come to adjudication some years after it had happened. People sometimes gave dishonest evidence in court, regardless of the oath they swore to tell the truth. And aside the problems with gathering of evidence, ascertaining the correct position of the law can sometimes be difficult. And even at the highest level of the Supreme Court, judges may disagree on the correct position of the law. Yet, for all these shortcomings of litigation, all other considerations which had been present in the African way of resolving disputes were sacrificed just for the sake of getting a judge to pronounce judgment as to who was right and who was wrong. Added to these are some of the difficulties which were very succinctly stated in the speech of the Honorable Regional Minister that caused the delays, the lack of privacy, etc. Now, over the course of time, in Ghana, where almost everybody is related to the other person by reason of blood ties, marriage, clans, religious denomination, or old school ties, the word litigant soon assumed a derogative meaning. Indeed, it is interesting that when Ghanaians pour libation, immediately after they have asked their ancestors to give them long life and prevent untimely death, the thing they beg their ancestors to prevent is getting them involved in a dispute which will take them to court. And so in pouring libation, we say, this is a very succinct way that Ghanaians had of saying that litigation or adjudication was something that was to be dreaded and to be avoided if you could. These problems associated with litigation, however, have somehow been suppressed during the days when Ghana was under military rule and access to courts and the rule of law had not been emphasized. When in 1992 we adopted for ourselves a constitution based on the respect for the rule of law, there was an immediate explosion in the number of cases filed every day in the courts. The inadequacy of the judicial system was therefore badly exposed. The need to reform the justice delivery system could no longer be ignored. In looking around for ways of resolving these problems, it was discovered that, as with all the raw materials taken out of Africa, our traditional means of resolving disputes had been copied by the Western world, had been processed, polished, and formalized, and given the rather glorious name of Alternative Dispute Resolution, or ADR. It was therefore easy to see how ADR could be introduced into our court or other dispute resolution milieu as a means of decongesting the courts, speeding up the process, and making it more responsive to the true needs of the people in disputes, and generally providing a more appropriate dispute resolution mechanism. So in 1993, when a new Courts Act, the Act 459, was passed, it contained Section 72 and 73, which provided that it was the duty of a court to promote the reconciliation of the parties and the settlement of cases outside of court whenever this could be achieved. Further progress towards the formal introduction of ADR into our dispute resolution system was made when 3 Ghanaian lawyers representing the bench, the bar, and academia were sponsored to undertake a formal program in ADR at the Center for African Peace and Conflict Resolution, University of California, Sacramento. It is my pleasure to indicate that one of the 3 persons is here with us in the person of Nana Amegache, who just left the hall and will be back soon to take part in the program. The other person is no other than the Honorable Lady Chief Justice, Justice Georgina Theodora Wood. And so you see that ADR takes people to great places in Ghana. These trained persons, in conjunction with the Judicial Service, also came back and trained several other persons, 10 of whom were also sent to the same institution in California, Sacramento, in the year 2002 to train as trainer of trainers. It is my pleasure to indicate that I was one of those 10 persons, and I'm here with you today. When we returned to Ghana, in conjunction with the first 3 people, we organized the first ADR settlement week in Accra in the early part of 2003. The settlement week had been preceded by 1 week of ADR training, and one of the persons who participated in that training and was also very active in that landmark ADR settlement week is also here with us in the person of Justice Irene Dampa, who is now chairing the ADR program of the Judicial Service in Ghana. I remember you particularly when you were in those small rooms, going up and down and resolving the tremendous number of cases that we did in that 1 week. In 2004, the new High Court Civil Procedural Rules, which was promulgated, had in Section 58 a provision which provided for the establishment of commercial courts in which ADR processes were mandatory, and all parties whose cases were sent to the commercial courts had to undergo what is known as a judicial settlement conference or a pretrial conference. In the meantime, ADR was introduced as a course in the Ghana School of Law and eventually became one of the subjects which mandatorily must be studied by all persons who aspire to become lawyers in Ghana. The Judicial Service also introduced the court-connected ADR system, and the Judicial Training Institute was very instrumental in training a large number of persons who act as mediators in the court-connected ADR process. In the meantime, an ADR bill was drafted and it was eventually passed into law in the year 2010. Ladies and gentlemen, this has been a very brief history of how ADR was formally or has formally been introduced into Ghana. As I've already indicated, ADR is supposed to be alternative dispute resolution, but I dare say that we must rechristen it African dispute resolution. This is something that came from us And even if we don't have the intellectual property rights registered, at least it should be named after us, African Dispute Resolution. The basic premise of ADR is that although using the legal position to resolve disputes has its benefits, there are times when it is more appropriate to explore options other than the legal position as a basis of resolving a dispute, taking into consideration the nature of the dispute, the parties involved, and other important considerations. These options and processes are varied, and present at this training are persons who are specialized in some areas of alternative dispute resolution, who I'm sure will find time to share their specializations with you. To the participants, I say that you have a unique opportunity to be a part of the growing body of persons in Ghana and beyond who are working to provide people with alternatives to litigation as a means of resolving dispute. I commend this training to you, and I hope that you give it your best shot. And looking at the array of people who are here to work with you, I have no doubt that as we did last year, we will have persons coming out who will immediately go into the field and resolve disputes, as you heard the Vice Chancellor indicate. Thank you very much, and I wish you all fruitful deliberation.